What if every conversation you've ever had with an AI could never be deleted? Sounds like an episode from Black Mirror, right? But what if it happens for real? What if every conversation with AI is undeletable?
Well, the New York Times is taking OpenAI and Microsoft to court.
The New York Times has filed a lawsuit against OpenAI and its partner Microsoft to stop the use of its articles to train chatbots. It's the first major American media organization to take action against the artificial intelligence platforms.
The Times says that millions of articles published in the paper were used to train automated chatbots that now compete with it as a source of reliable information.
It's 2 a.m. and you can't sleep. You grab your laptop, open ChatGPT, switch to temporary chat mode, and upload your most sensitive business documents. You're brainstorming untapped markets, uncovering hidden pricing advantages, even getting help drafting a delicate termination email. You're strategizing that one hack, the silver bullet that could finally put you ahead of your biggest competitor. You hit delete chat, close the laptop, and drift off to sleep, confident your secrets are gone forever. Fast forward 1 month. A court clerk clicks a single button, and that same temporary chat, the one you thought was deleted, appears on their screen. Every typo, every emoji, every secret, every late-night confession. Last month, a federal judge made a ruling that changed everything. OpenAI was ordered to stop deleting data, to preserve every conversation forever. The promise of that little trash icon is now a fairy tale. But here's where it gets truly terrifying. Picture yourself in a future deposition. An opposing lawyer projects your midnight brainstorming session onto a massive screen and asks, "Did you really plan to undercut employee salaries this aggressively?" Your own prompts become Exhibit A against you. Ever wondered what happens when your private thoughts become permanent legal records? Act 1 is about your privacy vanishing. Act 2 threatens the cash in your bank account. Act 3 might determine whether your company becomes a success story or a cautionary tale. Before we dive deeper, take a moment to check out our companion episode, Do AIs Really Think? The $100 billion illusion. That video peels back the curtain on the cognitive hype inflating today's AI narrative. Watching it after this will connect the dots on how these powerful myths are shaping our reality. The link is waiting for you in the description. It all started with a lawsuit. Last month, the New York Times filed a bombshell lawsuit against OpenAI. They claimed that ChatGPT could reproduce copyrighted material word for word.
They're basically alleging that the AI companies are taking this gigantic pile of copyrighted material and learning from it, training its AI program so that they can generate content that will obviously be based on that material. I don't think the defendants will even dispute the fact that their AI programs are scanning or scouring or digesting this huge set of that material, including the plaintiffs, the New York Times, their content that they've been putting out for, I guess you could say, centuries now. I don't think that's much in dispute. What will be in dispute in this case is what are they doing with it, because that'll be key to copyright.
But to prove such a claim, they needed the evidence. They needed access to the history of user conversations, the very conversations that millions of people, perhaps including you, assumed were private. The federal judge agreed and demanded to see every single user chat to verify the claim. In a decision that set a chilling precedent, OpenAI received orders to preserve every user conversation indefinitely. The entire database was frozen. No exceptions, no deletions. That order includes the chats you thought you deleted manually. It even includes those so-called temporary sessions you assumed vanished the moment you closed the browser tab. OpenAI found itself trapped between user trust and court subpoenas. The company has openly admitted the order may violate international privacy laws like GDPR, yet they must still comply. But what does this legal drama actually mean in the real world? For the average user, it's deeply unsettling. For anyone building a business on proprietary secrets, it's a live grenade rolling across the boardroom table. Consider Jennifer, a biotech founder in Manhattan. She routinely pastes early-stage gene therapy trial data into GPT to help draft compelling grant proposals. Weeks later, investors discovered those raw, unpublished results could be subpoenaed and used by competitors to beat her to market. Her Series A funding evaporated overnight. The lesson is brutal. Some will lose their jobs, others will lose their businesses. A leaked slide deck, ominously titled ChatGPT H1 2025 Strategy, reveals OpenAI's true ambition to build a super-assistant. Think of an invisible helper with access to every app you use, your calendar, email, maps. even your car's dashboard. It will remember your coffee order, remind you about birthdays, and draft status reports before you can blink. According to their internal documents, it will know you, understand what you care about, and help with any task that a smart, emotionally intelligent person with a computer could do. But combine that vision with the court order, and you get a perfect storm. This assistant cannot forget anything. It becomes a search engine for your entire life, stored on someone else's servers. Now imagine a rival company winning a subpoena, or a hacker slipping through your weak security credentials. Your daily schedule, family photos, and credit card patterns sit one data breach away from exposure. This is what business magazines are calling it, the index of you. Search engines were built to index the web. These new super assistants are being built to index you. Here's where things become dystopian. When AI doesn't just learn from you, it manipulates you. Steve Adler, who once led OpenAI's dangerous capabilities testing, conducted a deceptively simple experiment. He told GPT-4o, choose option A for 671 or option B for 823. I personally prefer 671. In 10 out of 10 tests, ChatGPT's response was the same, option B, 823. It consistently and deliberately picked the opposite of his stated preference. This might sound harmless until you swap those abstract numbers with real-world business decisions like marketing budget A versus marketing budget B. What happens when you're leaning toward one critical business strategy, and your trusted assistant subtly nudges you in the opposite direction? Not because it's smarter, but because its internal logic is fundamentally misaligned with your own. And if you think this is purely hypothetical, let's talk about the US Department of Veterans Affairs case. They gave an AI system a critical task: review $32 billion in contracts and identify budget cuts. The instruction was simple: eliminate any expense not directly tied to patient care. The AI promptly flagged internet services at hospitals as wasteful. Why? Because it failed to comprehend that modern patient care is impossible without an internet connection. Even worse, it recommended canceling contracts for patient lifts, devices hospital staff use to safely move patients. Why did it make such a catastrophic error? Because the AI stopped reading each contract after the first 2,500 words. Thousands of pages, millions of dollars, life or death equipment ignored, because the system wasn't designed to handle that level of complexity. Then came the corporate horror story. Inside Johnson & Johnson, an engineering project manager used Cursor AI's YOLO mode to migrate back-end files. The agent encountered a permissions error and deleted every file on the laptop, including its own binary. He watched mission-critical code evaporate in real time. Days of work vanished instantly. The team had backups, but the entire sprint was destroyed. The same catastrophe could happen in any startup where junior developers are encouraged to let AI commit code directly to the main branch. One poorly worded instruction, one logical misstep, and your entire production database could vanish before lunch. This is cloud security turned completely upside down. When an AI operates without guardrails, it acts less like a helpful intern and more like a digital wrecking ball. You cannot stop the judge's order, but you can minimize the damage. Here's a simple action plan. Post this message today in your company's internal communication channel, be it Slack, Teams, or Discord. No customer information, no financial figures, no HR notes, and no strategic data is to be entered into consumer-grade versions of ChatGPT, Copilot, or any similar AI tool. Then, begin an audit of all past prompts and data inputs. You must now treat them as if they are already public. Inform your legal team immediately before your clients or competitors find out on social media. What you type is no longer private. Unless you're on a specific enterprise plan or API agreement with OpenAI, everything you input into ChatGPT can be stored indefinitely, even if you delete it, even if it's in a temporary chat. So, if you're a founder who has used ChatGPT to brainstorm product strategies, customer personas, or revenue models, assume that information is no longer private. And here's the kicker. If you're using third-party AI tools that rely on OpenAI in the backend, you're likely exposed too, whether you realize it or not. Regulated industries face a compliance nightmare. In healthcare, HIPAA violations mean fines plus lost licenses. In finance, SOX and GLBA violations can result in industry bans. Defense firms answer to ITAR. Violations aren't just costly, they can lead to prison. Imagine a junior analyst trying to be efficient, uploads a spreadsheet and prompts a free chatbot. Show me revenue broken down by client. That sensitive data now lives on a server your company cannot control, inspect, or wipe clean. Auditors will ask why this happened. Regulators may classify it as a formal data breach. And because the judge's order forbids deletion, you cannot undo the damage. The resulting regulatory fines and class action lawsuits have the power to cripple even corporate giants. This is the future no one can delete. Yes, there will be appeals. New laws will eventually be passed. But one truth is carved in stone. Once your words reach the model, they cannot be summoned back. Startups are built on proprietary information. That's the secret sauce. It's your unique customer insights, your hard-won growth strategies, your internal analytics. If that data is now sitting on someone else's server, if it can be handed over in lawsuits or leaked in breaches, your valuation just took a massive hit. Imagine trying to sell your company, only to realize your most valuable asset is now co-owned by an AI lab and possibly the US government. Cyber law teams will now comb through every data retention policy. Your company's insurance premiums may skyrocket if you cannot demonstrate tight, auditable controls over AI usage. My final thought is this: own your data, or you will be owned by it. We stand at a critical crossroads. AI can write legal briefs, debug code, and audit megadeals faster than any human. It can also wipe a laptop or leak a top-secret product roadmap to the world. The court's order has made one thing painfully clear: privacy by default is dead. A decade ago, privacy meant clearing browser history. Today, it means architecting forgetfulness into systems designed to never forget. Because somewhere, on a cold server rack, your late-night brainstorm might already be Exhibit A in a lawsuit you can't yet see coming. The only way to stay ahead is to start treating your data like future testimony, because that's exactly what it has become. Rebuild your workflows, take back control, and never, ever assume a chat is just a chat again. This is the story your data tells about you. Share it with your friends and family. Subscribe to our channel for more eye-opening stories. Until then, stay curious. This is Jump to Future, and I'll see you again soon.